Good afternoon again. Thank you for joining us. I want to let you know that we are now offering MCLE credit for California attorneys and continuing education credit for workers' compensation claims adjusters. So welcome everybody. All attendees must be on the webinar, able to see the slide presentation and attend for the entire hour to receive credit. Again, I'm going to say this one more time because it's really important. You must watch the presentation in order to receive credit. We are not providing credit if you called in on the phone only and cannot see the slides. Thank you so much for understanding. We're just trying to be compliant for when we get audited. Please visit our website at bradfordbarthel.com for tons of information about Bradford and Barthel and our value-added services. I'm going to quickly tell you about 3 of them. Please check out our training page. It has over 80 hours of CE credits available to claims examiners. Additionally, you can register for any of our upcoming webinars. I think we're scheduled out to June at this point, so you can register for several of our upcoming monthly webinars. Our April webinar is available for registration now. I think everything except for our May webinar is up. And then we are not offering MCLE for our recorded videos. We're only offering CE to claims examiners for now. Our B&B blog, which is written by our awesome Bradford and Barthel attorneys, releases an average of 2 articles a week on current workers' compensation topics. If you haven't checked out our blog or even our recent articles, I highly recommend that you take a look. And finally, our AMA analysis and rating department fully analyzes and annotates medical report shortcomings, outlining sections that either need to be bolstered or undercut, depending on the client's objectives. Please take a peek at your GoToWebinar panel and find the handout and the questions section. You should see several sections in there, your audio, the attendee section, but find the handouts and the questions section. You will find a copy of today's PowerPoint presentation downloaded in the handouts section. Additionally, the PowerPoint is posted on our website on the training page under today's topic. If you have any questions during today's presentation, please enter them in the questions section. We will be answering questions today, and we will do our best to get as many of them answered as possible. We have Lauren Coleman and Nasir Adil from our Oakland office leading today's training on Joinder, setting the table for resolution of cumulative trauma claims. I think you're in for a real treat with these 2, so let's go ahead and have them introduce themselves. Nasir, would you like to go first?
Sure. Hi, everyone. Good afternoon. My name is Nasir Adil. I am the managing attorney of our Oakland office. We primarily cover the Oakland and San Francisco boards. We do cover Stockton, and we're open. Nowadays, everything's virtual for the most part anyway, so we're flexible. But I've had the pleasure of being with the firm for over 13 years now. If anyone has any questions, I know we're talking about CTs, joinder, contribution, and those fun topics today, but if anyone does have any questions about, if you get a panel and you're not sure what doctor to strike, or, you have a treatment question or whatever, just feel free to email me. Lauren's contact info is on there also, but, we're very big on email and contacting, attorneys and having that one-on-one attention. So just because we're presenting today doesn't mean we're not available afterwards for any questions you may have, whether it's on topic or not. One of the reasons why I think, Lauren, who's going to be presenting primarily today, these topics are going to be important because, in claims and handling CTs, joinder, contribution, there are things that come up throughout the course of a claim. I can guarantee whoever's listening in probably has 1, 2, 3, or 4 files right now that are, in that joinder contribution stage. So, these things, they're important to preserve our rights and to make sure that everything is done timely and there's a process. And some of this stuff may seem intimidating, but there's always a rule and a path to follow. So without further ado, I will introduce Ms. Lauren Coleman.
Hi, my name is Lauren Coleman. I am out of our Oakland office. I have been with the firm since 2021, and I've been doing comp now coming up on 8 years. So today we're going to talk about joinder and cumulative traumas. I did do a past presentation on cumulative traumas and elections. So if you have any questions, a lot of this is very case-by-case specific. So if you have any things in your case that you feel like maybe it applies, maybe not, this is a general overview, but feel free to email me. My email is listed in the PowerPoint, and I'm happy to get more specific about any cases that you have. So let's go ahead and get started. So first, we're going to do an overview of joinder. So first of all, joinder only applies to cumulative traumas when there can be multiple employers or insurance carriers. Basically, Joinder allows for other employers and insurance companies to be joined because when applications are filed, the applicant's only allowed to list one employer, one insurance carrier, one TPA usually. And then at that point, that one employer can then join in anyone else in the CT period that could potentially have liability. And it makes them become parties, and that does play a role because there are special implications to the parties in a case versus potential defendants. And we'll go over all of that. Joinder in general, along with cumulative traumas, is covered by Labor Code Section 5500. And the most important part of Joinder is, of course, contribution, which means that when the case is settled, if we are the administering carrier TPA, that you can get reimbursed for the percentage of liability of any other employers and or insurance carriers in the CT liability period. So where does this fit in? So whenever you have a cumulative trauma, there are always questions that you should ask. So the first question you should ever ask in a cumulative trauma is, are there multiple defendants? Once your client is either joined or you receive an application and it alleges a CT, you want to immediately ask, when is our coverage period? If our coverage period is not for the entire year alleged, then who else can we bring in to help cut down our liability and share in the cost of administering the claim? The second question you want to ask, if there are multiple defendants, is whether there was an election. And when there's election, that basically selects one defendant to administer the claim, but then also act on behalf of all other party defendants. They can settle the case even without the signature of other defendants, and everyone is jointly and severally liable for that settlement, regardless of whether they signed on to it. You also want to ask if everyone is signing the settlement documents. Again, if there's an election, technically they are not legally required to sign to be bound by the settlement, but it is best practice to try to get everyone to sign on to avoid potential disputes over the amount of settlement, liability, etc. later on in the contribution phase. You also want to ask, are there any potential additional defendants that have not been joined? This can happen sometimes when there's, for example, construction workers where it's kind of individual policies, site specific, and they only work somewhere for 2 weeks. And there may be two other bigger players that were joined, but you don't want to forget about the kind of small sliver, few days here, couple weeks there. Those defendants should also be joined as they share in liability. And finally, you want to ask, has a petition for contribution been filed? Because even if you join the other defendants, and you have an election, without the petition for contribution, then you don't have your right to seek reimbursement for their share of the liability for anything you've paid on the claim, including the settlement. Okay, so the first question is why join? And again, the biggest issue there is going to be contribution. Labor Code Section 5500A, it limits liability for CTs to 1 year immediately preceding either the date of injury or whatever the date of is established. So the other thing you want to notice particularly about this section is a lot of the time for a CT, the date of injury isn't known, right? So it is technically the 1 year immediately preceding, but the date of injury for a CT is still a factual determination. I think we've all seen general CTs that are pled for the entire period of employment, over 1 year, 20 years, 3 years, however long the applicant was employed. Obviously, there would only be 1 year of liability, but there may be a factual dispute as to what period in that alleged 20-year period should be the liability period, and that's where joinder comes in. You want to just make sure that you join anyone who could potentially have coverage until that date of injury dispute is resolved. The main indicator of whether you should file a petition for joinder is if your client does not have insurance coverage for the entire alleged cumulative trauma period. If you know that you are not on liability for the entire year preceding the date of injury that's pled, you should immediately be looking for other dependents to join, and discovery to identify those defendants should be completed as soon as possible, especially in cases where you only have, a couple weeks of coverage, so there would be a co-defendant that has a majority of the CT period. Joining other parties early also avoids discovery-related delays and litigation, because once they are a party, you have stronger rights to seek information about their coverage and employment that you may otherwise have to seek through a subpoena or other kind of litigation device that now they actually have the duty to notice once they are joined as a party.
And Lauren, if I can just jump in, I know the common question is, when to join. Obviously, if you have all the information at the beginning, but as we all know in practice, oftentimes the doctor's opinion, which can change on 5500.5, or since CTs are factually determined based on Labor Code Section 5412, is there's gonna be different stages where you can join a co-defendant. Ideally, at the beginning of the case, you have everything, but realistically, everything's going to keep popping up as discovery proceeds. So this can happen at different stages of the claim, right?
Yes, and we will cover specifically the timing of joinder, but the short answer is anytime before settlement, as soon as you have the information sufficient to join a defendant. So sometimes we know they worked for someone else, or there's another carrier, but we don't have their coverage information. As soon as you have the name of the employer, ideally the insurance carrier, not so much the employer, but the insurance carrier, their address, that's really the two things that you need to be able to join them, because there is a notice requirement, and we'll go through all of that. But yes, as soon as you know who to join and their information for service, that's really at the point that you should be joining another defendant. And like I said, there's no deadline. There's at no point before settlement where you can no longer join. You can join at any point. And in select cases, you can actually join after settlement, and we'll touch on that a little bit later. Okay, so I want to take a note about elections when it comes to why joinder. So Section 5500.5C is what gives the applicant the right to elect against one or more defendants. It's very rare that they actually ever elect against multiple defendants, and usually we encourage them to elect against the defendant with the highest share of liability. But an election can only be made against a party defendant, so the party has to have been joined. And then once the election is made, they now operate on behalf of all defendants, and they can resolve liability at any point on behalf of everyone without necessarily providing notice to anyone else. That again is poor form, but I think we've all seen cases where perhaps that happened to us. I know SCIF sometimes does that, where they'll just settle multiple claims for everyone, and then we have to kind of duke it out over contribution. And the other important part about election when there's multiple defendants is that if there is no election and you settle the case, there can be a dispute as to whether you actually resolved the case on behalf of all the defendants or just your client. And I know often when we negotiate settlements, the sheer value of the case, it makes it look to us obvious that you resolved for everyone. But there are cases that have found that even though that may have been the intention, because there was no election, it was not found to actually be resolving everyone's liability. And so there's two ways around that. There's an election, and then just get everyone to sign. That's always best practice, because once they sign on it, they really can't argue. But we all have cases where maybe they're not responding, they're not signing, that's when you might want to have an election just as security, so that they can't pop up later after the case is solved and try to reduce their coverage because they didn't sign the settlement documents. Okay, so now we're going to talk about who can join. Almost everyone you can join. So are there more questions?
Sorry, just want to jump in. A lot of good questions on the cam over here. I feel like I'm hosting a podcast, but just
yes.
some good questions. I mean, one of them is a good problem to have. Pardon me for, I believe this is Ms. Alana Scott. What would we do if there's a time period where our insured does not have coverage at all? For example, let's say there's coverage from 2019 for the whole year, but in 2022, there's no insurance at all. That's called a good problem, because that's called the reason to get dismissed. If you've been joined, obviously getting parties joined is, and I know Lauren will get into it a little later, but joinder is what we all want to do. Judges are very low on the threshold to join parties. If there's basically any reason to join, judges will probably sign off on the joinder because it's easier to dismiss than to join. But basically, in that situation, Alana, I would go for dismissal. The judge may say, hey, look, we want to make sure there's evidence really establishing the 1 year of the CT is in 2019, not during your coverage. But if there's medicals out there saying that the CT is not during your coverage, I would highly recommend filing petition for dismissal. So thanks for the interruption, and I'll probably get back into more questions as we go on. But of course, Lauren, if you have more to add on, please do so.
Mm-hmm. Yeah, I'm feeling good about my presentation. So there's actually a slide on dismissal that'll be covered later in the presentation. But again, as Nasir said, basically, when it comes to dismissal, if you have no coverage at all, you want to seek dismissal. However, judges are extremely hesitant to dismiss a defendant, even if they have no coverage, when it leaves the applicant without benefits. So what is common practice is to do kind of a quick WCIRB search, try to figure out who has coverage, essentially do a joint petition where you join them and dismiss your client. And usually, as long as you have proof that you have absolutely no coverage, they essentially get subbed in as the defendant, and you're more likely to get a clean dismissal early. Otherwise, the judge is more likely to kind of maybe keep it on status conference and set you for several conferences until applicant attorney has the opportunity to conduct necessary discovery to make sure that a defendant gets joined. You won't be liable for benefits at that point because you have no coverage and you'll deny the claim, but you kind of still have the file open. You're racking up legal fees as we appear at these conferences. So it's always cleanest to try to do a little bit of upfront research, find out who might have coverage that's not you, and then join them while you dismiss yourself, and usually you'll get out pretty early in the case. Okay. So going back to who to join in like that situation, you're looking for who to join, right? So it's anyone who could be a defendant. So the threshold is extremely low. All you have to allege is that they were a defendant, or that the applicant worked for them, or that they had coverage during the cumulative trauma period. And again, in this, you want to think bigger, right? So just because the applicant alleges a certain cumulative trauma date. So this happens to all of us, right? So maybe in January, someone has surgery, but they don't file the app, and they go back to work, whatever. And then after they go back to work, they file the application. It's within 1 year, it's valid. But is the date of injury actually going to be when they filed, or should it be when they had surgery because they knew about the injury at that point they had surgery, right? So this is why the date of injury for a CT is a factual question. So if we can't ever agree and we go to trial on it, the judge will ultimately decide at what date there was injury and or disability and knowledge. But you don't want to limit yourself just because it was pled 6 months later. You want to keep in mind the potential that it could be moved up 6 months, which may take 6 months out of your coverage period, depending on when your coverage period started. So it's anyone that is alleged to exist. So you are allowed to join any other defendants in, let's say, outside that 1 year, if there's a dispute as to when there was knowledge of the injury, or we think that the CT date could be moved. This happens a lot when you have cases that are just a specific injury, and then we're ready to settle the case and we go to the QME and they just miraculously find a CT, and they usually make it some random date like the last date they worked or the same date of injury or whatever. Those are kind of flimsy date of injury, and you might want to argue, well, if he was having symptoms sooner, he knew, so we'll move the date forward, back, try to limit your coverage period, and we're allowed to do that. But you just want to make sure, if you're trying to make those arguments, that you join any potential defendants that may be added because we're moving the date around. And again, usually the general approach from the WCAB is they're going to join and let everybody fight their way out. So when you're in doubt, just join potential co-defendants. And generally, you have to offer proof, like the applicant said he worked there, or we have a W-2. But if you really just know that they work there and you don't have anything, you can technically just file alleging that there's coverage, and they'll probably be joined.
Thanks for letting me butt in. A really good question from Brian. It's actually touched base on what Lauren just kind of hinted on. The question is, regarding the date of injury for a cumulative trauma, can you discuss determining the correct date of injury pursuant to Labor Code Section 5412 versus date of injury as the last year of injurious exposure? So great question. I'll ask a question to you all. You guys probably know, you all may know, but date of injury or the date of a cumulative trauma, is it a medically determined question or is it a factually determined question? I think Lauren already gave the answer, but it's actually factual. And that's important because doctors, they know CTs based on 5500.5, which is the last date of injurious exposure. So, in medical school or in workers' comp school, they say, okay, last year of injurious exposure, that means that's the CT. And doctors will say, well, he or she worked through, 1/1/22, so do the math. It's 1/1/21 through 1/1/22. But that's not always the case where the actual date of injury is, because again, it's the last year of injurious exposure. Injurious is the main word right there, and injury is factually determined based on 5412. So based on Labor Code Section 5412, as Lauren pointed out, that's based on disability and knowledge. So the CT isn't always the last year of employment. It can easily be shifted around based on disability and knowledge. So I know it's very technical stuff. A lot of attorneys don't follow that properly. Judges don't either. But when it comes down to the actual labor code and actual application, it's actually two different things, 5412 and 5500.5. Great question.
Yeah. And to specify a little bit, 5412 is what's going to govern the date of injury, and the 1 year period of injury of liability tolls from that date. So basically, if you go to trial on a 5412 date of injury dispute, as soon as that date is found, then the 1 year is 1 year back from that date. So they kind of work in tandem. And that's why I said, so that again, like Nasir said, if the QME finds this general CT period, oh, well, he worked through this day, injurious exposure, but I had a case like this where we had up until settlement, we agreed like this was the CT date as the cumulative, or the QME pled. And then when we were in contribution and we were trying to split up the benefits paid, there was a note that the applicant basically said that he stopped working because of his back for the CT 3 months before the date that the QME found for the end date. So we were arguing over what medical treatment should be paid, because while it predates the 1 year, so when you go 1 year back, he actually had some medical reports for that body part 3 years before the 1 year, 3 months, sorry, before the 1 year liability period. And so we were able to negotiate more contribution because we weren't going to basically try to litigate the 5512. Well, obviously he went off 3 months before, so we should move the CT date back. We opted not to do that and settle the case, but it did help in the contribution phase, because obviously these medical bills are related to your body part, not the other body part, but you can still negotiate, and that's what a lot of this ends up being. It's very rare that we end up, especially if coverage for the carrier is spanned multiple years, we're not necessarily going to argue what the date of injury is, because you kind of have 100% exposure either way. But it is a good negotiation tactic with co-defendants for contribution, because even though they may not have liability in the CT period, they would have to litigate the issue too. So you might leverage the cost of litigation for a little bit more contribution on the medicals, and we have medicals that they're probably liable for anyway. And that's the issue with contribution. It's subject to arbitration, so most of it is resolved through these kind of negotiations because nobody actually wants to go to arbitration. Okay, so when to join? I know this was a question that came up earlier. As soon as possible. But what does that mean? So there's no prescribed time for a petition for joinder. So there's no deadline. There's no point at which you're not allowed to join other than maybe settlement. So it should be filed, though, as soon as you have the necessary information. So that includes the name and address of any additional employers and or insurance carriers, TPAs, all of that. So a lot of this information can be found. Most commonly, we use a WCIRB search. You can kind of do the informal coverage search, find out this day, this is who had coverage. You can join everybody, or you can put in a period and a period of time, and then it'll have all the insurers, and then you can just literally use that and join all of them. A word of caution, though, is you don't always want to use the addresses listed on the WCIRB website. If you really don't know their address, you want to go to the California Department of Insurance website, because on that website, it lists the designated person for service on that defendant, and those addresses usually don't always match what's on the WCIRB. And this is important as we get into the procedure of how to join. But notice is the key component for joinder. The new employer or insurance carrier just has to be noticed of your petition for joinder. They have the opportunity to respond, but they don't have to respond, but you have to be able to prove that they were properly served and had notice of this petition for joinder. So as far as things to consider, as far as the timeline of the case, is at the very least, regardless of when you join everyone, all potential co-defendants should be joined at the time of settlement. This is a stop sign. Even if you're getting a great deal and you're going to CNR the case, you still want to hold off if you need to file a petition for joinder. You can join multiple defendants at the same time, but it is worth delaying submission of a settlement to make sure everyone is adequately joined before the settlement. You can do an election as part of the settlement documents where basically you could join everyone, give them notice, then elect against yourself to settle on behalf of everyone. And then now you've reserved your contribution right. And you can settle on behalf of everyone because there's an election in the settlement documents as long as everyone is served. But you cannot do that. You cannot settle on behalf of other defendants, even with an election, unless they are joined as a party. So you just want to make sure everyone has been joined before you submit any settlement documents. In extremely rare cases, the WCAB has allowed for joinder for contribution after the case in chief has resolved, but that's only because a petition for contribution was filed and there's no deadline for joinder in a contribution matter. If you get to this point, absolutely try to consult an attorney. I'm happy to help you. You really want to try to join before settlement, but there are rare cases where after settlement, you might be able to still join people for the sake of contribution, but it is extremely narrow and case by case. Okay, so why timing and joinder matters and why it's best to join early. So first and foremost, we don't want to get DOR happy here, especially if you are a minority defendant. So if you only have 1 week, a month of coverage, you wanna pump the brakes on filing a DOR. Why? Because only defendants joined prior to the first hearing can participate in discovery of the proceedings, which means that you wanna file your petitions for joinder before you file for a hearing in the event you're a minority defendant, because you basically want them to be allowed to participate in discovery so they can be elected against and proceed with the discovery and administer the claim so you don't have to when you have only a month of the CT period. So if anyone is joined after the first hearing, they're essentially along for the ride and they're bystanders to the case, right? So basically they can conduct limited discovery regarding the time, place, and duration of the alleged employment only. So basically they are allowed to do enough discovery to confirm that they are in fact a proper defendant and seek dismissal if it's found that they're not, and that's it. They can't participate in the QME process. If they want to do any discovery regarding contribution, it has to wait until after the case in chief is resolved, but they should still be served with the settlement documents and have the opportunity to sign as a best practice. So again, you want to just make sure that the timing is right. We don't want to get DOR happy and then basically you're now the only defendant that can participate in discovery, because then you might have to administer the claim when there's another defendant that has a majority of the liability that should arguably be administering the claim. So you don't want to get too trigger happy. The first thing you should be thinking about in a CT is joinder before filing any kind of a DOR, even if you don't have liability. Okay, so on that same note, how to join. So you file a petition for joinder. It has to be served on the parties being joined, properly served at the correct designated person of service. Employers, this is really tricky, right? Because you just have to kind of look up who they are, like where this is the W-2 address, but is that the service address? We do follow basic civil procedure laws where if it's your place of business, you can reasonably serve at your place of business. So if you find a pay stub, a W-2, it has an employer name and an address, it's pretty accurate that you're going to be able to have properly served them at that business address. It's trickier with insurance carriers. And that's why I direct you to the California Department of Insurance website, because they have, designated person for service and an address. And even if we work with these insurance carriers all the time and we know the address where they want their mail, sometimes you really just either want to serve that common address that you know, and as well as the address on the California Department of Insurance website, because that's basically the person they have designated for service, and it covers all insurance. So not just workers' comp, it covers automobile, everything. But they're their person who gets service. So you just want to make sure you at least serve that person. And this is important because we've all had the case where you serve a party and they don't respond. And so what do you do at that point? You want to try to make them show up. You want them to try to come to the table, talk about contribution. But for purposes of joinder, they don't have to respond. They are required to be given the opportunity to respond. It is subject to a 10-day notice requirement and an opportunity to be heard. So most commonly, you'll file your petition for joinder. You will get a notice of intent from the judge that says, I'm going to join you unless you get an objection. if an objection is filed, you get set for a status conference. And the other issue is technically, while only an allegation of liability is required to justify joinder, it is still best practice to try to offer some degree of proof. So even if you have the applicant's deposition where he said, oh no, I totally worked for them, that's fine. You can offer a page of the transcript that shows, or just state that the applicant testified to working for this employer, or print out from the WCIRB that has the insurance carriers for that period of time. All of that's sufficient, but you do probably want to offer some degree of evidence with your petition, even though technically it is not required. Question?
Thanks for letting me jump in. A lot of great questions coming in. Just to add on to Lauren's point, of course, WCIRB coverage confirmation should ideally always be included as an exhibit for the petition for joinder. Back in the old days of 2018, before 2018, we used to be able to write into the WCIRB. Now everything is online. I believe if you asking the WCIRB, it's about $20 per year of confirmation based on whoever covered the employer. Also, applicant's depo testimony is great, as Lauren pointed out. If you have any medicals, those are highly relied upon by judges also, PTP reporting, PQME reporting, so that's always good. A few good questions coming in. One question is, it says, why is EAMS now showing the start date of the CT period as the date of injury when everyone else uses the end date? I wish there was a real legal reason for that. Sometimes it just comes down to the person at EAMS who's literally entering something in for the state of California based on what the application says. Of course, that can be amended, but whatever EAMS lists is not legally correct, not legally binding. It's just kind of something that everyone uses, but the actual documentation that we all use for the actual pleadings, that's what controls. So I know it's frustrating, but unfortunately, EAMS sometimes is definitely not a perfect world. Another question, Lauren, I think this might be kind of to what you were saying. What kind of evidence or facts do you need to establish injurious exposure for the preceding year? So I believe it's asking kind of what kind of evidence is needed or fact to basically establish injury for a CT.
You don't. So you don't actually have to offer evidence of injurious exposure. You need to offer evidence of coverage and employment. So unfortunately, we'll cover this more on my dismissal slide. With joinder in particular, a judge is more than happy to join everyone and have us fight our way out, right? So you don't have to prove injurious exposure at all. You just have to prove that they worked during that cumulative trauma year, and that's it. They will then have to argue, if they want to get out as a party, that they had no injurious exposure. He was seated the whole time. He really just carried pillows all day as the job. Like, that's their argument to make. You don't have to prove injurious exposure. You only have to prove employment and coverage. I'm sorry if that was unclear. That is an important distinction to make. The other thing is a form of evidence, proof of employment. This has come up in a couple of my cases. When you don't join the proper employer, so there's a lot of DBAs, there's a lot of umbrella companies, sub companies. Sometimes AA doesn't care, and they just join whoever, and then that's not the right person who has the insurance coverage. So we're kind of running around trying to find out, like, there's no policy for this person. Who's the carrier? When that happens, and you find the proper DBA or overarching employer, they still have to be joined. So for that information, I have a case where we found out the proper employer name because of wage statements and a W-2. You can offer that as the evidence. That's basically like, he was employed by this person in this year because I have a W-2, and that'll get them joined. And if we need to get the sub company dismissed, we can figure that out, but it's more important that everyone who needs to be joined is joined, not that anyone who shouldn't be there is joined. That's not really an issue. We can work out liability later, but there's a lot of ways to offer evidence. And again, if you're just really having issues, they don't want to, it's a small employer, they don't want to respond, you're subpoenaing them, you can still file the petition for joinder without the evidence and just make a good faith plea to the judge as to all these discovery issues that you're running into, and they'll probably still join them. Okay, so when you're joined and you don't want to be joined, we're going to talk about defenses against joinder. There really aren't that many. The most common defense is that you have a lack of employment and or insurance coverage during the CT period. You can prove that by the WCIR printouts. You can offer parts of your policy, and most often they will grant joinder and then let us all fight for a way out. So basically, they almost always will join you, but then you can file a petition for dismissal outlining why you don't have coverage, and then they'll usually grant it. But they still are going to make you join and do the litigation to file the pleadings to get dismissed. Okay, so dismissal as a party. So again, as I noted, they're generally hesitant to dismiss, even if you have no coverage, when it leaves the applicant without a defendant. So usually, if you're the only defendant and you have no coverage, you want to do some degree of research to find out who is a potential proper defendant, who they worked for at all during the alleged CT period, and this also applies for specific dates of injury, right? So this is the one time where you might want to join in a specific injury, and that is if you're the incorrect defendant. So on the date of injury, be it a CT date or a specific date, if you do not have coverage and you have proof of that, that will honestly only get you halfway there. What you want to do is run a quick search on the WCIRB website, basically see that the employer insurance carrier is not you, and then offer that as evidence, get them joined, do a joint pleading for joinder and dismissal, offer your proof that you are not a proper party, offer the printout from the WCIRB website that says they are. The judge will probably issue a notice of intent to join and dismiss, have a status conference most likely, and then you can get dismissed. But please note that almost all dismissals are without prejudice, which means you can be brought in again if they find out for some reason that it shows that you actually do have liability. Or again, if this is the CT period, you don't have coverage, you get out. Then they want to go to trial on the 5412 date of injury issue. The CT period is moved. If now you have a little bit of coverage, a week, a month, you can then get rejoined because the date of injury is now changed. So that's something to consider too. It doesn't happen often. And judges are allowed to delay their determination. So they might say, yeah, we're going to dismiss you, but I want another status conference, or I want the new defendant to appear, which is annoying, but it is common because they want to just make sure that there is someone for which the applicant can receive benefits from before they kind of leave it as a wash, which, while unfortunate, is just kind of how our benefits delivery system works. Okay, so the last note's going to be on unjoined defendants. So what happens if defendants aren't joined? Well, in general, this is really more of a case law driven legal issue. There's not a ton of law on it. So basically it comes down to these kind of law school legal concepts of like express intent. What was meant when we settled the case, like who was included. And generally, the general understanding is that when you settle a case, and there are parties who are not joined, who may have liability, their liability is not resolved by the settlement. So we're going to take a step back for this because there are rules when you're resolving CTs that actually say that you don't have to ever resolve an entire cumulative trauma. You are allowed to resolve it in parts. So what does that mean? That means if we have our defendant, our insurance carrier, if at any point we can make an offer to the applicant and basically say, we'll pay you X amount to resolve our liability only. The applicant can accept that, and that will basically settle out your client only, and then leaves the other defendants on the hook for the rest of the medical treatment. This is very rarely done because the applicant usually wants a larger payout. They want to make the claim as big as possible, and then they get paid one big lump sum, because what's the point in getting paid a little bit now and then still having to continue to litigate and be bound by the workers' compensation system? So like your case keeps going, but you just take a small part out. And if you settle now and then you're found to have liability later, you've already resolved it. So it's not often that this happens, but it can happen in specific situations. For example, you're a 2-week employer, the applicant needs money now for whatever reason, everything's in litigations, TD's delayed, we're going to go to trial on it, whatever. Maybe they want to accept $20,000 to get your little subcontractor out of the CT. They can technically do that. But because you're allowed to do that, you can only resolve liability for the parties joined at the time through an election where that person is now legally designated to be able to act on behalf of all defendants. And the important thing to note too about elections is that everybody has to be served. So everybody, all of the other defendants, there's nothing they can really do to fight an election, but they have to be notified that there is an election. So, and like I said, you can put it in the settlement documents, but then they have to be served before the settlement documents are submitted. And then you can resolve it on behalf of everyone, or you just have everybody sign off. But if everybody signs off on the settlement document and you find out there's one or two more defendants that could have been joined, but were not, their liability is still open. And so this is a big point of contention for contribution disputes. Again, contribution is governed by arbitration. So what does that mean? So you can file a petition for contribution, and then we fight out how much everyone has to pay. And so there are cases with elections where you settled the case and there's no election. You don't have proof of the election. You don't have a copy. I've had a case where we can't find a copy of it. They settled the case. They settled 4 cases. They weren't even a party to one of them. Very messy settlement. And so all of this comes into play at contribution, where we're basically arguing, the applicant, in theory, when you are unjoined and the case is settled, your liability remains open. So in theory, the applicant could have accepted this lump sum settlement to settle the case, and your liability is still open. So they could then still basically file a claim against your defendant. Again, all of the statute of limitations and all of those deadlines apply, but in theory, they could then bring a claim against this unjoined defendant and start benefits over again. That almost never happens, right? But it could. And so that's really what you're going to be arguing for contribution. So more often than not, when you settle a case, realistically, everybody thinks that it was settled for everyone, right? But legally, this case, Ventura versus Dana Point Cleaners, if you want to scare yourself into remembering to always join everyone and do an election, I mean, it basically says that there was language in there that says it includes all people. And the WCAB said, no, that's not enough. They weren't included. They named the defendant Zenith in that case. It includes all of these people who have liability during the CT period, including Zenith. But because Zenith was not joined as a party, their liability was not resolved, even though there's express language in the settlement that says that their liability was included. Again, this is a rare case. It's more of like a freak accident case. The WCAB is not going to open up these kind of cases without reason. Someone has to basically challenge the settlement agreement. Otherwise, it all goes to arbitration under a contribution dispute under 5500. It doesn't really end up in front of the WCAB, which is why they really won't act on it, but they will interpret a settlement agreement. So that's where, when it comes to elections, you're kind of going between arbitration and the WCAB, because you would have to go back to the WCAB for interpretation of the settlement agreement. And then once they decide, yes, Zenith is included, no, Zenith wasn't included, you would then go back to arbitration to argue your rights for contribution. And so more often than not, because nobody wants to do that, you do reach some kind of monetary agreement that says that their liability was included. You don't always want to alert AA about this. Rarely you do, because I'm sure AA usually thinks that usually the amount of the settlement is adequate, regardless of whether everybody's liability was included. But so usually the applicant's more than willing to just take the money and go. Applicant's attorneys happy to let sleeping dogs lay. So this is really just a technical defendants fighting over contribution issue. I've never really seen a case where liability technically wasn't resolved and the applicant tried to actually seek a new case, though there are cases in the universe of workers' comp where that has happened. It's just not common. So then again, to avoid this, when in doubt, just file a petition for joinder, get everybody joined, and then it ensures that the liability was included in the event of an election, because even if they haven't responded the entire time, you have the right to join on their behalf. Okay, are there any questions on the last 2 slides? Because I know that this stuff can be confusing. I'm not seeing, yeah.
Hello. So yeah, I mean, a lot of good questions coming in. Nothing that I see particularly on the last 2 slides, but when you finish this one up, I'll get back to 1 or 2 that I can, but I'm trying to answer some in the question section as well. But again, if anyone does that pop up, feel free to type them in. We'll try to get to them. Thank you.
I have about 2 more kind of referencey slides. We wanted to leave time for questions. So first is the research. In the slides, I did provide to you the 2 direct links, because both of these, it's the insurance company website in general, I tried to include like where you can actually look up the information for the proof of service, but it's a very long URL. But you can go to the insurance website. There's a tab that says carriers. You can kind of click through the menus and you get the proof of service. You can look up, type in the name of the insurance carrier you're looking for, and it'll pop up, and then it has all of their subsidiary insurance companies, and it has the designated person for service. The WCIRB coverage search, that one will take you directly to where you can put in the employer information, the date you're looking for, and it'll generate an informal report. At this point in time, the WCAB for the most part treats the informal reports as formal reports, but you can only go back so far. I believe it's 3 years. And if they do have coverage further back in their records, but to get that, you have to request a formal report, and it comes at a cost. Like Nasir said, I think it's about $20 a year per year of coverage or something like that, but it does come at a cost, but you do get a more exhaustive kind of list. But the basic free online search usually is enough to get what you need. You just have to make sure you do it on time, because sometimes these CTs go way far back, right? Or there's a prior claim for a CT, and you know yours is now, and you're trying to do apportionment to prior injuries. Like those ones might not come out because they're too far back. So you do want to make sure, and it's just good practice that generally when you get a new claim, you run a WCIRB search just to make sure that you are the proper employer. But you want to try to do it as soon as possible, just because you can only go 3 years back. And then finally, I have a reference sheet for starting points if you have a cumulative trauma in general, labor code 5500. If you've got a joinder question, it's 5500.5. The procedures are, it's the code of regulations, 1038.2. Elections are covered by 5500.5 B through C. I did do a webinar on this issue last year. So if you're more interested in elections and cumulative traumas, I have a full presentation on that. And I'm offering this little nugget here for joinder after the award. This is the case where they did allow joinder after an award issued because a petition for contribution was filed, and there's technically no limitation on when you can file a petition for joinder for contribution. So it happens to all of us sometimes. If you realize after an award's been entered, you stepped a case, you settled a case, and you should have joined someone, for sure get your contribution petition filed. You can do that for a year at any point, but specifically the deadline is a year after an award or a year after settlement. So you have 12 months after settlement to get that filed. And if you get that filed, in some cases, you can still join defendants for contribution only. But it's an uphill battle because they're going to say they're not liable, they're entitled to a QME, all this additional discovery, but it can be done because that comes at a cost. And like I said before, much of resolution of contribution is negotiation. So you would then leverage the cost of their litigation with the cost of your contribution and try to reach a number you can both live with to resolve contribution. But that is obviously a very case-by-case specific situation. So feel free to email me or anyone else if that's the case that you're dealing with.
I know we're wrapping up on time shortly. I think I'd try and get to 1 or 2 questions. Good question out there. What determines a formal election from a claimant or applicant or AA? It's pretty low threshold. But Lauren, basically, how is an election really made official?
You serve it. So that's basically it. You just make anything clear. It can be a letter, it can be a formal pleading. A formal pleading is always best, but basically it's like, you know, applicant hereby elects against X, usually it's just insurance carrier / TPA, to administer the claim. And then once that, I mean, it can be an email. Emails are kind of bad, but basically it's all about service. So you have to then take that election and serve it on all of the party co-defendants. The other thing to notice is if you join someone after an election, they need to be served with the election. So as long as everyone's served, that's with any kind of crayon written election from the applicant that says, I want this person to administer the claim, that's all it takes for an election. And like I said, it can be written into the settlement documents, but they have to be served on all party defendants before the settlement document is submitted. And usually that has to be done after they sign, because you don't want to, if it's unsigned, then the applicant hasn't agreed to the election. So basically you would get your settlement document signed with the election in it, then you'd have to wait, serve the party defendants. I would wait the 5 business days to ensure that they received it, and then you would file. And that would be enough to be an election. But really what's important about the election is service. So you can't really just put it in there, settle the claim, and then get it approved. Like, they have to have notice that they can now be bound by a settlement without their signature. So again, a lot of it's just letting the party defendants know, but there's not a lot we can do to defend against an election.
Yeah, I've seen it so informal as even on minutes of hearing, AA will just write in that applicant elects against this carrier, this TPA. Very low threshold. It's like filing a petition to reopen. You basically got to put something in writing and serve it. It's a very low threshold, but oftentimes we get it via pleading. But informal actually does work so long as it's served. I know we're running short on time. We have about less than 5 minutes remaining. One thing I do want to say, some of the great questions out there, Joseph Gayet asked he made a comment actually, basically about kind of controlling the Joinder process a little bit. Joseph, I saw your question. I agree with you. Essentially, oftentimes we get intimidated when we're the ones elected against, because it's like, oh no, now we're the ones doing discovery. We're the ones writing to the doctors. We're the ones taking the depo. But I think oftentimes is that actually puts you in the controlling position, pole position, if you will, because then everything's subject to reimbursement anywhere, contribution. So the cost you're paying for med legal, let's say it's 50-50, you're going to get the cost back anyway, so long as you reserve all your rights. So it's not a death sentence by any stretch to be the elected against party. Oftentimes it allows you to be a little more in position to ask the right questions at depo, kind of being more aggressive or more upfront with the doctors on the dates. You get to be the ones who are controlling the discovery rather than getting a petition for Joinder last day, saying that you're responsible for 90% of the CT. Then you got to work your way backwards. So by no means is a death sentence to be the elected against party, but there are steps to do in that situation. But I know we're running short on time. Try to answer as many questions as possible. I apologize if we were not able to answer all of them. Great turnout for today's presentations. We thank you all. If anything does come up again after this topic or after a presentation, feel free to please reach out to Lauren, reach out to myself. We're more than happy to answer any questions that come up, whether they're big questions, small questions, anything else. But I'll let Tammy come back on and I'll try to answer one or two last questions in the meantime as well.
Okay, thank you both so very much. And thank you all for all the wonderful questions. I think it makes the training more interesting to have you guys pitch in. So thank you so much for that. I just have some really quick information to provide here, and then I'll let you guys get on with your day. I know you're busy. Certificates for CE and MCLE will be emailed to you this afternoon. The PowerPoint can be found on our external website under training and today's event. I wanted to mention again that per your great feedback, we created a big blue button that says View PowerPoint PDF. It's under each event, so we always keep those PowerPoints under the recorded event, so they're easier for you to find now. Our next webinar is April 19th at noon on estimating PD and reserving PD advances with Timothy Musak from our AMA Analysis and Rating Department. That's all I have for you today. Thank you again so much for joining us, and enjoy the rest of your week, everybody. Stay dry. Take care.